Vaishramati Ghosh from National Law School, and today we'll be discussing the topic relating to rights of the senior citizens in the context of human rights perspective. The aging of population is a matter of global concern. Aging is a phenomenon which happens for every individual from the time they are born in society. From being born as a child, we pass through various phases like adolescent to teenager to adult and then to the factor of being an elder person. This particular phenomenon is a part of our natural processes, living processes. So in this context, every individual and every society is facing this entire concern relating to the issues and concerns of the senior citizens. But then the question is, why is it that we have to segregate or make the senior citizens treated as a different section altogether? And this is because in the last 100 years, that is from the beginning of the 20th century, we have seen that there has been a global increase in the population of the senior citizens. What we have seen is that in the last 60 years, more than 740 million population are above the age of 60 years. During the phase of 1950 to 2010, that is in the context of just 60 years, the global life expectancy has increased from 46 years to that of 68 years. And it is almost expected that by the year 2020, we will touch 1 billion population as far as the older population is concerned. This kind of makes us concerned as regards why. Why has there been such a phenomenal increase as far as the one section of the population is concerned and their longevity is concerned? This is because of the fact that there has been major developments in the area of medicines, in the area of technology. Medicines have increased the life expectancy. Antibiotics and various other forms of medicines have ensured that people, the average age of people, they are living in a healthy manner is far more than what their fathers and grandfathers used to live. And with that, the advancement in technology has made the day-to-day life of individuals performing of their daily chores much simpler. And in that context, the physical exertion which people otherwise required to survive through their lives has decreased to a great extent. So this has given the people much better lifestyle, quality of life has improved, whereby the life expectancy of the population has increased significantly. So if we see from the Indian context, we see that the population of India, that is the senior population, is expected to touch a figure of 240 million by the year 2050. This increase of population, if we compare it from the ordinary increase of population, that is the average citizen's age, then this increase is more than 325%. And that with regard to the older population, that is older, that is above the age of 80 years, the increase is supposed to be almost 700% more higher when we are actually comparing with the ordinary age population increase, which is at the rate of 60%. The question is that if that is so, why should it be a matter of concern? It becomes a matter of concern for all sections of the society, both at the international level as well as at the national level, is because it involves major dependency on the state resources as well as on the family resources. Till recently, the population that is above the age of 60 years were deemed to be part and parcel of the family structure, that is part of the joint family system. And it was the responsibility of the children to take care of their parents. The state intervention and the state role, particularly in traditional societies like India, was supposed to be a very, very minimalistic. But with the growing globalization, there has been a steady migration of population from the place of their residence to other places in search of work, from rural areas to urban areas, from one city to another city. Thereby, the younger population in search of work had to leave their traditional homes and move into different cities. and thereby they left their old parents, infirm parents, in the hands of other family members or third-party caregivers. And this kind of over a period of time has increased the vulnerability of the senior citizens. In addition to that, of course, there has been the entire people who do not have much support system in their families. What do we mean by the term senior citizens? Ordinarily, aging is a process of life cycle. After living a productive life, a person becomes old and thereby they lose their functional capacity. But as far as the legal definition is concerned, under Section 2H of the Maintenance of the Welfare of the Senior Citizens and Parents Act of 2007 is concerned, senior citizen means any person who is a citizen of India and who has attained the age of 60 years or above. This definition is a legal definition. It does not have any impact on the physical or mental well-being of an individual. This definition of senior citizen does not take into consideration any form of medical certificate trying to associate an individual whether or not they have a functional capability to lead a healthy life. It is just a legal definition. But ordinarily, when we are trying to associate certain attributes to being a senior citizen, then we of course have to say that once a person is considered to have attained the age of or have crossed 60 years, there is deemed to be a decline in the functional capability of the individual, and also there is a general deterioration in the health of the individual, both in terms of physiological health as well as psychological well-being. So this is what kind of is technically labeled as being a senior citizen. Why is it a matter of concern for the elder people? Why should it be bothered about the human rights of elder citizens? This is because senior citizens suffer from some major problems which makes their conditions far more vulnerable when we compare it with the well-being and the health conditions of other individuals. For one, they suffer from with the age, they suffer from various health-related issues like knee problems, back aches, hip problems, walking problems, hearing problems, eyesight problems. All these things makes them dependent upon other members of the society, their children and third-party caregivers. In cases wherein they do not have the support of children because of the fact that the children have moved and started living separately because of family problems or because of work-related issues, then this individuals, the senior citizens, start suffering from loneliness, and thereby they suffer from various forms of isolation, which may result into psychological problems for them. This, in addition, kind of often gets associated with other problems such as economic crisis, because with the increase of age, what often happens is the physical health of the individual suffers. The cost of medication is so high that most often senior citizens who are largely dependent upon their savings or the pensions which they are earning from, they are not in a position to maintain the cost of the medicines and the other related medical expenditures. So thereby they start suffering from various forms of economic hardships. Then often they are treated as burdens in the family. If there is a person who is suffering from chronic illness, it becomes a matter of financial crisis for the family, and this over a period of time creates unhappiness, disturbances in the family's concern. And this again may result into subsequently ill treatment and abuse. And people, that is the old people who are living in, let's say, geriatric centers or old age homes, it is often found that they suffer from all these kinds of problems, both in terms of isolation, feeling lonely, suffering from economic hardships, as well as all forms of physical ailments. Among the older population, there are people who are suffering from extreme vulnerabilities, and that is in terms of old women. If we compare an old man vis-a-vis an old woman is concerned, we would find that the old woman suffers far more than an old man is concerned. And that is because the old women, even in the house, are restricted 24/7. They do not have an outlet whereby they can move. They become the unpaid caregivers for their grandchildren. they help in the cooking in the family, and most often they suffer from various problems which are not even often highlighted as matter of concern in the families. Then of course there is the disabled population. When a person is old and they are suffering from disabilities, then they definitely become dependent upon the third party people. They become dependent upon their children for making them move from one place to another. They become dependent upon them for accessing their finances, from going to the banks and doing various other activities. So therein they become totally dependent upon the people, whereby they lose out on their individuality as well as independence. Associated with another important class of vulnerable population is the rural poor, because people who are living in the rural areas, once they reach an age wherein they cannot take care of their personal needs, they suffer from greater crisis because they suffer from access to clean drinking water, because in rural areas one may have to travel long distances to collect clean drinking water, which they may not be in a position to do. Secondly, because of their age, they may not be able to go out of their houses to use the sanitation facilities, because most houses do not have toilet facilities in their homes. So all these factors makes them suffer in a much greater manner compared to old population, that is older men in general. So there are large problems which the older population is suffering from. So according to United Nations report on human rights of older persons 2010, they have identified 4 major concerns, that is 4 major human rights violations which the older people are suffering from. The first one is the discrimination. Discrimination which is often generally will be associated on the grounds of gender, race, ethnicity, religion, disability, health and socio-economic problems, becomes further aggravated with old age. An old person suffers from various discriminations much more compared to any other section of the population. The second is of course the issue of poverty, which we already discussed. That is, with poverty it brings in homelessness, sufferance of malnutrition because of inaccessibility to good quality food, unattended chronic diseases, lack of access to safe drinking water and sanitation, unaffordable medicines and treatments, and income insecurity. This makes the poverty factor is one of the most crucial factors which makes the lives of older population a very, very grave and critical one. In addition to that, what we have often also noticed is that the third point which the United Nations have highlighted, that is violence and abuse. Violence and abuse does not necessarily have to be physical ones, but it can be both in terms of emotional torture, sexual violence, which old women often have subjected to, and of course financial abuses. The savings of the parents, the savings of the older people are accessed by the younger population, and they do not provide the necessary care in return which they are expected to provide. And added on to this, of course, there has been the problem of government insensitivity. Government insensitivity is because of the fact that the state till recently was not in a position, or they never thought it necessary to provide specific care to the concerns of the old population, because they always felt that it is the responsibility of the family members. So there is today, if we look into the Indian context, we would see that there is a major absence of state care as regards providing residential facilities for the old people, providing home care programs, or providing any form of geriatric services to the old population. So these are the 4 major concerns which the United Nations have highlighted, which we need to take into consideration while we are discussing the topics of human rights violations of the older population. So what are the consequences? We just discussed the concerns. So the consequences is something which we have to be very, very clear about. The responsibilities of aging is a matter of concern for both government and the family members. And this is because largely of the issue of budget, the finances. With the growing age, the people's needs becomes more, and so thereby they are deemed to be a concern for the younger generation, wherein who will have to bear the increased responsibility of bearing the medical expenditures and other forms of expenditure as far as their parents are concerned. Similarly, it is important for the government also to start making allocation of higher resources so as to provide for better medical care facilities as well as other forms of residential facilities for the senior citizens. So the consequences as far as aging society is concerned is something which has to be seen both at the micro level as well as at the macro level. The human rights concern of the older citizens has been a matter of concern from the time we have started the discourse on human rights issues. The Universal Declaration of Human Rights have not specifically spoken about the concerns of the senior citizens, but all the various human rights which they have highlighted, particularly Article 25 of the Human Rights Charter is concerned, specifically talks about the fact that it is the duty of the state to ensure that there is no discrimination among the citizens on various factors including age. And it is also the responsibility of the state to provide for adequate living facilities to people and people who might need help in the form of social securities because of factors due to age. Similarly, the International Covenant on Economic and Social and Cultural Rights, even though have not specifically mentioned about age-related factors or age-related concerns, but what we can possibly read in those covenants are the fact that it specifically makes it mandatory for the states not to discriminate among citizens on various factors. And the Committee on Economic, Social and Cultural Rights, recognizing the fact that yes, there has been a gap in the covenant as regards the concerns of the senior citizens are concerned, have mentioned in their general comments that it is the responsibility of the state to protect the rights and ensure privileges to the senior members of the society. Similarly, we can see other major international covenants like the Covenant on Civil and Political Rights, Convention on the Elimination of All Forms of Discrimination Against Women, that is CEDAW, or Convention on the Rights of Persons with Disabilities. All these conventions have within their mandate provided for the fact that there should not be any form of discrimination, particularly on the factor of age, even if they have not mentioned it specifically, but it is deemed to be implicit in all these different international documents on human rights issues. And in the context of the CEDAW, they have specifically mentioned the fact that we need to take special care as regards rural women is concerned. We need to take special care of people suffering from disabilities. And also it has been mentioned that once a person reaches the senior age, we need to ensure that we provide them with various social security benefits in the form of pensions. So international conventions have recognized the concerns of the senior citizen. May not be in a specific document. United Nations was always concerned with the concerns of the senior citizens. Even though in the UDHR they did not specifically speak about the old population per se. But in 1948, a draft resolution on a declaration of old age rights was drafted and which was circulated among its members. That particular resolution recognized a set of rights which are very, very crucial for our understanding as regards the needs of the old population. The first one is the right to assistance. Every aged person has the right to full protection by his family, and in the case of destitute persons, it becomes the responsibility of the state to provide them with necessary protection. The second right is the right to accommodation, where it is recognized that every citizen, and particularly the old population, has a right to a healthful place of abode, wherein they can be assured of minimum levels of home comfort. The third one is the right to food. The right to food includes right to healthy diet, which should be commensurate with the age and the physical conditions of the individual. The fourth one is the right to clothing. Adequate clothing based upon the circumstances and the climate where the individual lives becomes part of the basic entitlement of an individual. The other important rights which the declaration kind of recognized was right to care and protection of physical health, right to the care of moral health, right to recreation, right to work based on the productive capacity. Of course, this becomes very important because just by attaining the age of 60, an individual does not lose their capability to work. So what becomes important is to provide for them a suitable working area wherein they can use their experiences, they can use their talent, and thereby they can live a dignified life. The other rights include the right to stability and distress-free life. So it is the responsibility of the state to provide them with a safe and secure environment wherein they are not unnecessarily harassed by their family members or third-party caregivers or any other individuals. And most importantly, the declaration recognizes the right to self-respect. Every individual has a right to live in dignity and with the self-respect, and it is the duty of the state to protect and ensure the same. In 1982, we find the first major world gathering on the issue of aging under the auspices of the United Nations. So, in Vienna, there was a World Assembly on Aging, which saw the coming together of all the major countries of the world, and during that, the declaration relating to the United Nations Principles of Aging was made. It consists of 5 major principles, that is, right of independence, that is, every individual, that is, every old person needs to be given the right to be self-independent. The second one is right to participate. The third is right to receive care, right to receive self-fulfillment, and right to dignity. These are the 5 major concerns which was recognized at the World Assembly on Aging in Vienna in 1982. Based on that, it made a commitment. It asked the states to provide the necessary commitment to introduce various plans of action whereby these 5 major principles could be implemented. And accordingly, the plan of action based on 7-point agenda was identified. And this 7-point of agenda, which every country was supposed to give a commitment towards, was first on the issue of providing with necessary health and nutrition, making policies relating to protection of elderly consumers. Third is providing for adequate housing and ensuring giving them a necessary environment, safe environment. Fourth is right of them to live within their families. Fifth is to ensure, in case necessary, provide adequate social welfare policies to implement social welfare schemes. The 6th one is with reference to providing the senior citizens with their right to education. And the last is trying to ensure and trying to develop some kind of an income security based on either employment or pension facilities. So these are the 7 areas which the United Nations thought of as necessary for developing a plan of action which every country needs to give a commitment to, and should further develop their plan of action based on those agendas. After the Vienna Convention, the concern for the senior citizens has been taken on a much more active manner by the international community. There have been, under the auspices of the United Nations, there have been a series of meetings of the different countries wherein they have given their commitment towards promoting the cause of the senior citizens, as well as they have tried to develop what can be said to be the further plans of actions. So in 2002, there was the Madrid Plan of Action wherein the United Nations Principles for Senior Citizens were accepted, was reiterated, and also further focus was made to as regards what needs to be done by the various countries. And herein they kind of said that the focus should be made on developing policies which will ensure the development of older people. There should be policies which will take into consideration the health and the well-being of the senior citizens. And lastly, it is the responsibility of the state to create and enable a supportive environment where senior citizens can live in dignity. Subsequent to the 2002 Madrid Convention, there was the Shanghai Plan of Action as well as the Macau Outcome Document. And India has been a signatory to all these major documents. To sum up, what are the major concerns of human rights, or what can be described as the major human rights concerns for the elders? We can divide it into 4 major categories. The first is right to equal participate in their various activities, right to receive adequate medical attention. The third is right to access affordable housing communities, and third and most important is right to social justice and protection. So these are the 4 major areas of concerns which has to be identified, which has been identified under the human rights context, as regards being matters which needs to be taken into consideration by the various state entities as well as other private entities when we are talking about the concerns of senior citizens and their human rights issues. Now we will move on to the Indian context. Indian Constitution has recognized the right of every citizen to live a life of dignity, to enjoy fraternity, liberty, equality. With regard to the concerns of the senior citizens, of course, so being a citizen of the country, they have access to all the fundamental rights which the country provides for them. That is Article 14, that is right to equality, Article 19, right to liberty, and of course Article 21, that is right to life. In addition to these rights, there is the Directive Principles of State Policy, which has imposed certain mandatory obligations on the state to take steps to ensure the well-being of the citizens. Among these rights are the Article 41 and Article 46. Article 41 provides that the state shall, within the limits of development, make effective provisions for providing public assistance in case of individuals, that is, people suffering from unemployment, old age, sickness and disablement. So it becomes part of the state policy to take care of people who are at the age of being old citizens. And Article 46 provides the fact that it is the responsibility of the state to promote with special care the economic interests of the weaker sections of the people and to protect them from all forms of social injustice and all forms of exploitation. So to sum up, we can say that the Indian Constitution basically demands that the state must ensure improving the quality of life of senior citizens without any discrimination and to protect and safeguard the right to equality, dignity and security. In addition to the constitutional provisions, we have certain legislations which have tried to take care about the concerns of the senior citizens. These legislations can be divided into two categories. One are the personal laws and the other are the secular laws. Under the Hindu Adoption and Maintenance Act, there is a provision, that is Section 20, which states that it is the responsibility of every Hindu child, whether male or female, is to take care of their aged parents or infirm parents. So parents who are not in a position to take care of themselves because of their ill health or because of financial inability, they can claim maintenance from their children, and the children are duty bound to provide for their financial maintenance. On the other hand, the various other religious laws, the personal laws of other communities are concerned, even if they do not have a specific mention regarding the issue of maintenance. But the personal laws of all these communities, whether we talk about the Mohammedan community, we talk about the Christian, Parsis, others, there is a general expectation that the senior members of the population should be taken care of by their family members. As regards the secular laws are concerned, and that is a very, very important point for us, for our discussion today, is because these legislations are the ones which are trying to promote social justice in society. And therein the responsibility of the state becomes immense as regards the implementation is concerned. Among the various provisions, the most important one has been till date has been Section 125 of the Criminal Procedure Code of 1973. Section 125 has been recognized as a tool for promoting social justice. What does Section 125 provide? Section 125 Clause 1 Subclause D provides that if any person having sufficient means neglects or refuses to maintain his father or mother, who are unable to maintain for themselves, a magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his or her father or mother at such monthly rate as not exceeding 500 rupees in the whole as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. The monthly allowance has today increased from 500 rupees and it depends upon case to case. Section 125 of the CRPC is the most important provision as regards promoting the economic welfare of the senior citizens are concerned. And it has been this section which kind of imposes a penal liability on the children to look after the well-being of their parents, and any failure to do so will subject them to form of penal actions and consequences. The most important legislation after Section 125 CRPC, and which is today the fundamental law relating to the rights of the senior citizen, is the 2007 legislation of the Maintenance and Welfare of Parents and Senior Citizens Act. This legislation was enacted by the Indian Parliament when there was large number of reports as regards abuse of senior citizens and different forms of tortures which the senior citizens were subjected to by their family members, children and other individuals. So the Maintenance and Welfare of Parents and Senior Citizens Act, the essential features of this legislation is, first is to provide for the maintenance and welfare of parents and senior citizens as has been guaranteed under the Constitution of India. The second is to ensure that they receive a monthly maintenance under the order of the tribunals. And third is, it has made neglect and abuse of elders as a punishable offence. Now we will discuss some of the major provisions of this legislation. The first important thing which we need to look into is the definitions. Section 2, Clause A, defines children. And defines children, which is interesting as far as this section is concerned, refers to not only to son and daughter, but it also includes grandson and granddaughter. So the liability under the statute, of course, will be on the son and the daughter, but in case in the absence of son and daughter, the responsibility can always be brought to the shoulders of the grandchildren as well. The second important definition is on the term maintenance. Maintenance under the statute does not simply mean economic maintenance. It has provided a far wider meaning to the term maintenance, that is Section 2B speaks about that maintenance includes provisions for food, clothing, residence and medical attendance as well as medical treatment. So the children are under the obligation to provide for food as well as clothing as well as provide them with residence, and also to necessarily take care of them in terms of medical conditions. Section 2, Clause D defines parents, which includes both father and mother, which are biological as well as adoptive as well as step-parents, whether or not the parent is a senior citizen. So as far as parents is concerned, the concern is not that of whether or not they have reached the age of senior citizenship, but the fact is that they are the parents and it is the responsibility of the children to take care of their parents. And for those senior citizens who do not have any child or children, for them the responsibility will be extended to those legal heirs or relatives who are in all likelihood to receive the property or the possessions of these individuals. So Section 2G states that relative or any legal heir of the childless senior citizen who is not in a minor and who is in possession of or would inherit his property after his death would be deemed to have the liability under the statute. Section 4 of the statute is the most substantive provision of the law. It speaks about maintenance of parents and senior citizens. It provides that a senior citizen, including parent, who is unable to maintain himself from his own earning or out of his property owned by him, shall be entitled to make an application for maintenance under Section 5. A parent or a grandparent can make a claim against his one or more of his children not being a minor. In case of a childless senior citizen, against his relative, if he is having sufficient means and is in possession of the property of such person or would inherit the property of such senior citizen or to the proportion in which they would inherit. The obligation for maintenance extends to the fulfillment of all his basic needs which are necessary for the individual to lead a normal life. So Section 4 entitles every senior citizen as well as parents to have a claim against their children or legal heirs whenever they feel that they are not in a position to maintain their day-to-day life because of their financial inability. And under the statute, maximum maintenance of Rs 10,000 can be ordered by the tribunal for the purposes of maintenance. Section 5 provides for the procedure which is to be followed for the purposes of claiming the maintenance under Section 4. An application for maintenance should be made by the senior citizen or the parent. In case he is incapable, then in that case he may appoint some other person or a voluntary organization to make application to the tribunal. Or in certain circumstances, the tribunal can themselves take suo motu action or cognizance of the same. The statute further provides for the payment of interim maintenance. So during the pendency of the proceeding, the tribunal can also direct the children or the legal heirs to make some direct payment of monthly allowance due as interim maintenance till the final order is issued. The procedure which the tribunal is required to follow under the statute is based on principles of natural justice. The tribunal is required to give notice of the application to the children or to the legal relative, and also to provide them with an opportunity of being heard, and thereafter they are required to conduct an inquiry to determine the amount of maintenance which the parties needs to pay to their parents or their senior citizen. And there is a time frame which has been provided for disposing of such application, and that is within a period of 90 days, the tribunal must dispose of the application. One important provision in the statute provides for the fact that it is not necessary for a person, that is a parent, to make a claim against all his children. The parent can make a choice between one or more of the persons against whom he wants to file for a maintenance claim. What happens if there is a failure to pay the maintenance? Under the statute, if there is a failure to pay without sufficient cause, then the tribunal can issue warrant for levying the amount similar to the way it would issue an order for levying of fines. Once that has been issued and still there has been no payment of the amount, then the tribunal can order for imprisonment up to a period of 1 month or until the payment is made, whichever is the shorter period. However, the application for non-payment has to be made within a period of 3 months from the date on which it has become due. So that would mean that if on a particular date the party, that is the children or the relative, has failed to make the necessary payment, then within a period of next 3 months, the parents or the senior citizen must make an application to the tribunal asking them to ensure that the payment takes place. Otherwise, they would lose their right to claim the maintenance for the same. Where can the parents file this grievance? Under Section 6 of the statute, the parents can initiate the proceedings against the children or the relative in the district where they are residing or where they last resided, or they can even file the claim in the place where their children resides or their relative resides. In all such proceedings, the tribunal will have the power of a judicial magistrate first class, as has been provided under the provisions of the Criminal Procedure Code. If the tribunal finds that even after sending the notice, that the party do not appear before the tribunal, that is, the children or the relative fails to appear before the tribunal, then the tribunal has the power to initiate the proceedings and continue with the proceedings on an ex parte manner. What happens if the children are living outside India or the legal heirs are residing out of India? Then in that case, the statute provides that then the tribunal should be sending the summons through a notified agency as prescribed by the central government. And the central government has identified the Director of Social Defence of Aging in the Ministry of Social Justice and Empowerment of the central government as the nodal agency for issuing summons to children who are residing out of India. So that would mean that children who are residing out of India are also part of this particular legislation, and they can be held accountable under the provisions of the statute. Section 16 deals with the appellate mechanism. That is, from the order of the maintenance tribunal, appeals can be filed to the appellate tribunal. The appeal has to be made within a period of 60 days from the passing of the order by the maintenance tribunal. And the appellate tribunal has to follow the principles of natural justice, that is, they have to send notice, they have to give an opportunity of being heard to the parties, and then they would have to decide based on the evidences placed and the arguments made. There shall be no further appeal from the order of the appellate tribunal. So, appellate tribunal is going to be the final authority as far as the maintenance is concerned. Of course, one can go to the High Court under the review powers or provisions of the High Court or to the Supreme Court under 136, Article 136 of the Constitution. But otherwise, the order of the appellate tribunal will be final. And in such matters, on the issue of this application of this legislation is concerned, the maintenance tribunal and the appellate tribunal will be the only legal authority to try the matter. Civil courts will have no jurisdiction as regards issues of maintenance is concerned. The appellate authority is required to pronounce their order, that is the final order, within a period of 1 month. Section 23 of this statute is very, very interesting provision. It is one of the most important provision in terms of creating a deterrence in the minds of people. So many times, parents transfer their property in the name of their children, or they transfer it to some of their legal heirs, hoping that they would take care of them in terms of need. But what happens is that after receiving the property, there is a possibility that such individuals, such relatives, may not look after their parents, or they may not perform their responsibilities. In such cases, Section 23 becomes very crucial. It provides that any transfer of property which have been made, but there has been no fulfillment of the duty to take care, then such transfer of property will become void. It will be deemed to have been made on the ground of by fraud or coercion, and thereby the tribunal can revert back the order of transfer. The property which the parents might have given to the children can be ordered to be reverted back to the parents or the family member or the relatives to whom the property has been given. Such legal documents can be reverted back, handing over the possession back to their original owners. There is another significant provisions in the particular statute that provides for conciliation, that is, trying to provide for an amicable settlement. So under the statute, before an application is entertained by the tribunal, the tribunal can decide to refer the matter to the conciliation officer for an amicable settlement. The conciliation officer will meet both the parties, that is the parents and the other side, and then try to settle the matter without having to go through the process of the tribunal proceedings. And in case the conciliation officer has been successfully able to come out with a solution or settlement, then, and it is acceptable to both the parties, then the tribunal will pass an order to that effect. The conciliation proceeding has been done in order to ensure that there is lesser chance of animosity or any form of negative feelings among the family members. Under the statute, the proceeding which has to be followed in terms of this tribunal is a summary proceeding. In case there is a situation wherein a family member, children or relative who has been instructed to take care of the senior citizens or the parents is subsequently found to have abandoned them, have subsequently found to have left them permanently in a place without providing for due care for them, then the magistrate can initiate a legal action against such family members on the ground of abandonment of senior citizens, wherein they can be imposed with the punishment of imprisonment of 3 months and the penalty of maximum of ₹5,000. So this statute has not only ensured for providing maintenance to the senior citizens and the parents, but is also trying to look into the issues about trying to impose within them a sense of responsibility towards their parents in the course of performing their duties. A question might be asked here is whether lawyers can be appointed during the proceedings before the maintenance tribunal. The answer is no. Under the statute, specifically, it has been provided that none of the parties can be represented by any legal practitioner, that is, any advocates, So no advocate can appear on behalf of any of the parties as regards the maintenance proceedings are concerned. So an individual, if they want, particularly a parent, if they want, then they can approach the maintenance officer to represent them in such a proceeding. They can use the help of a voluntary organization as regards their claims are concerned, but they cannot use the help of a lawyer. Of course, we can understand why they might have said so. Is because, of course, lawyers are expensive, and it may not be possible for senior citizens, parents who are not in a position to provide for their own maintenance to even afford to have a legal help. And also many a times lawyers brings complexities and legal proceedings becomes far more complex, which may not be helpful in the proceedings of the cases concerned. This statute has imposed certain specific responsibility on the government, which is very, very important and necessary also. The responsibilities on the state government under the statute are: first is to ensure constitution of the maintenance tribunals at various district levels. The second is to frame the rules of procedure for the functioning of the maintenance tribunals. Third is to appoint an appellate tribunal. And fourth is to designate district social welfare officers or any officers not below his rank as the maintenance officer. So these are the primary responsibilities of the state government, which the state government is required to perform as regards implementation of this statute is concerned. One of the major provisions of this statute is trying to impose a certain responsibility on the government. So under the statute, every state government is required to establish old age homes. That is, they should establish one minimum old age home in every district of the state. And those old age homes should have a minimum capacity of 150 individuals. And not only they are required to set up these old age homes, but they are also required to frame rules relating to how these old age homes should be managed, what should be the minimum standards they must prescribe to, what should be the various types of services which should be provided in these old age homes. So it is the responsibility of the state to provide for those individuals who are living in a state of destitution, who may not have their own income or they may not be having necessary property to take care of them. In those cases, it is the responsibility of the state to intervene and build the old age homes and to take care of the citizens. In addition to providing the old age homes, the state government are also required to provide medical facilities. So under the statute, the state government is required to ensure the following things, that is, they should try to make beds, that is, hospital beds specifically available in government hospitals or hospitals which are funded through government money, adequate number of beds for the senior citizens. Second is, they must provide for separate queues for the senior citizens. They must provide for facilities of treatment for chronic, terminal and degenerative diseases. Special medical facilities should be provided for those kinds of illness. Then every government hospital at the district level should have medical officers who have the necessary experiences to take care of geriatric patients, and also they should try to promote research activities in the area of geriatric concerns in the government hospitals. So these are the major responsibilities which the state has towards ensuring a better medical facility for the senior citizens of the country. The success of a legislation depends upon its proper implementation. And implementation can only be possible when we kind of ensure that people become aware about this legislation. So the statute has also provided that it is the responsibility of the government to take measures to ensure there is adequate publicity given to the provisions of the statute, because one of the important problems which senior citizens suffers from is lack of awareness. They do not know about much of their legal rights. So this legislation can only be implemented properly when citizens come to know about the fact that there is a legislation which imposes obligation on them to take care of their parents, as well as the parents knowing that they can, in case the children do not take care of them, can have a recourse to the legal proceedings in order to ensure that they perform their responsibility. So another important thing as regards implementation is concerned is to build sensitization among the various government officials, including judicial members. So the statute has specifically provided that the government should initiate measures wherein they can conduct training programs for the purposes of sensitizing government officers, including judicial officers. And the last important point as far as the implementation of the statute is concerned, the district magistrate has been made the overall in charge of the implementation of the statute in every district. So these are the major provisions as far as the maintenance of welfare of senior citizens and parents is concerned under the 2007 legislation. And this is the most important legislation today in the country which tries to protect the rights of the senior citizens. On one hand, it has recognized and provided them with a legal right. On the other hand, it has also tried to provide them with an enforcement mechanism whereby they can enforce their legal rights. But there are certain shortcomings as far as this legislation is concerned, and there is a need to improve this legislation. In 2016 and 17, there has been certain private members of the parliament who have kind of proposed amendment to the legislation. So in 2017, there was an amendment which has been proposed, that is the Maintenance and Welfare of Parents and Senior Citizens Amendment Bill of 2017, which tries to ensure two important things. That is, they firstly tries to include a set of rights. So the 2007 legislation has enabled to frame a scheme, a mechanism whereby the rights of the senior citizens can be protected and enforced. But what it has not done is it has not recognized the rights of the senior citizens. What are their legal rights? So this amendment has proposed to recognize rights of senior citizens, and the four important rights which the statute recognizes are right to life with dignity and non-discrimination, right to legal aid, right to individual autonomy, and right to health care. So of course you might ask the question why right to legal aid becomes important. So even though it's true that during the tribunal proceedings you cannot have access to lawyers, but many of the times citizens are not in a position to know about their legal rights. So right to legal aid would actually may impose obligations on the national state or the state legal services authorities to conduct legal aid programs whereby they can make the senior citizens aware about their legal rights. So the right to legal aid becomes an important component as far as the statute is concerned. The other important inclusion as far as the amendment is concerned is the National Commission for Senior Citizens. It is like this being recognized that the tribunal is an adjudicating authority. But as regards the general welfare of the senior citizens are concerned, there has to be a think tank. There has to be a body which will decide on what policies needs to be adopted. So in that context, there should be a National Commission for Senior Citizens who will look into the issues like whether or not there should be a universal non-contributory payment of old age pension to the senior citizens, whether there should be a building of opportunities for senior citizens as regards income generation is concerned. Then there should be their power to look into general complaints, not just issues of maintenance, because senior citizens are often vulnerable by nature and they suffer from not only financial or economic hardships, but general abuse is there or neglect is there. So in matters of care, there should be a mechanism whereby they can raise other important complaints. So accordingly, if there is a deprivation of rights, if there is a non-compliance of the policies, or some state or government institutions is not following the provisions of the statute, there has been incidents of violence or sexual abuse, there has been a general abandonment or some form of begging, which beggary is taking place as far as the senior citizens is concerned, then this commission should be the authority to look into it. So the role of these amendments which have been proposed is important. If it is introduced in the 2007 legislation, then it will help to further strengthen the applicability of this particular statute. So till now there has not been much case of the Supreme Court regarding implementation of this statute is concerned, but we have few cases from the High Courts which have tried to look into the working of this statute is concerned. We have a couple of cases from the Allahabad High Court, and one of the cases is Majidin versus State of UP. In this case, one of the fundamental issues which was raised was the fact that in spite of the statute coming into force in 2007, there has not been any implementation of the statute. The state government had notified the fact of implementation, but there was no subsequent follow-up as regards notifying that the district magistrates are in charge of implementation of the statute. So in the Majuddin case, the Allahabad High Court passed an order saying that even though the issue of implementation of the statute is pending before the High Court, but in order to meet the cause of justice or ends of justice, it is important that the district magistrate must intervene whenever there is a complaint made to him as regards non-implementation of the statute is concerned or as regards neglect of senior citizens is concerned. And in this case, the court had ordered the district magistrate of Lucknow to look into the particular complaint made immediately and to revert back to the court within a period of 10 days, telling the court as regards what measures they had adopted. Another interesting case is the case of Janaki Devi versus State of UP, wherein the court recognized that the state government was, in spite of the fact that they have notified, but all the government officials who were in the different departments, they were totally unaware about the legislation. So it kind of clearly highlighted the fact that there was lack of adequate awareness being made by the state government, and this recognizes the apathy, the general apathy which senior citizens suffers from in the hands of government officials. And accordingly, the court ordered that the state government must create mechanisms and provide for maintenance of senior citizens and also provide for medical facilities. So senior citizens who do not have children and who do not have any near relatives who can possibly be deemed to be their legal heir, it becomes the responsibility of the state government to take care of them. And in that context, it is the responsibility of the state government to create old age homes, or it becomes the responsibility of the district social welfare officer and the district magistrate to appoint concerned persons who will be in charge of the taking care aspect of the individual senior citizen is concerned. They must ensure that this individual who has been given the charge to take care is actually performing their duty and is not exploiting the individual, is not exploiting the finances of the individual. So it is the responsibility of the state to take care of those people who do not have any near and dear ones to take care of them. These are some of the cases which came up before the court and which have clearly highlights that in spite of this statute being enforced from 2007, every state government has has implemented it in the context of notifying it. But in terms of grassroots level implementation is concerned, there has not been much major step taken. And ultimately it has been the judicial intervention which has required as regards ensuring the proper implementation of these statutes are concerned. Another interesting case is the case of Pawan Sharma versus State, wherein one of the children brought out this point that it is the duty of the parents, if they want to file a grievance under this statute, that they must make all the children party. But the court in this case, reading the provisions of the statute, clearly said that no, it is not the duty of the parents, or it's not compulsory for the parents to basically file a complaint against all children. It depends upon the parents as regards whom they think is not performing their duty, and accordingly file a case against that child who has failed to perform their duty towards their parents. And accordingly, Section 5 clearly states that an application can be made against one or more of his children who are not a minor. So there is no compulsion under the statute that all children should be made party as regards the statute is concerned. So the last part of our discussion involves regarding what are the state policies on the issue of senior citizens. In 1999, there was a national policy on older persons which was adopted by the government. This particular policy was in continuation with the government's commitment to the United Nations General Assembly, wherein they recognized that in 1999 was the year or the International Year of Older Persons. Under this particular policy of 1999, the government recognized that there are certain areas of intervention which they must look into. One was the aspect of financial security, the other is healthcare and nutrition, the third is the area of providing shelter, the fourth is providing education, then is the issue of providing welfare, and last is protection of the life and property of the senior citizens. So these are the major areas of intervention wherein the state must necessarily frame their policies. One of the major schemes which was introduced after this particular policy came into proposed was the scheme of Integrated Program for Older Persons, that is IPOP, under which financial assistance is provided to government, NGOs and Panchayat Raj institutions and local bodies for running and maintaining old age homes, daycare centers and mobile medical care units. So the government provides financial aid for the running of these facilities. Another important scheme which was initiated was the Indira Gandhi National Old Age Pension Scheme, under which the central government is giving a pension of Rs 200 per month to persons above the age of 65 years belonging to a family who is living below the poverty line, and which is to be contributed with equal sum of money by the state government, so that the beneficiary gets an amount of Rs 400 per month as pension under the Indira Gandhi National Old Age Pension Scheme. Other policies which was initiated for the older persons are like income tax rebate, discounts in railway fares, bus fares, airfares, providing of special medical facilities to the senior citizens. Another important policy under the 2011 policy is the concept of aging in place. It means that allowing the senior citizens to become old in their own houses, and for which certain facilities needs to be provided. That is, providing them with a housing facility, ensuring them that they have some decent income opportunities, providing them with home care services, pensions, as well as insurance policies should be made applicable to the senior citizens. Under this policy, it tries to encourage the family members, that is the younger generation, to understand that senior members are assets. They are there to guide them, and it is their duty of the younger children, younger citizens, to take care of the senior members as far as the social life is concerned. Other facilities which the government tried to introduce vis-a-vis this National Policy 2011 is concerned is to ensure or encourage long-term savings instruments and provide the senior citizens with credit facilities. Also trying to finance the state governments to build up old age homes, and also trying to ensure that the implementation of the maintenance of welfare of parents and senior citizens is done in an effective manner. The primary areas of intervention under the 2011 policy is, first is income security in the old age. Under this, they have encouraged they have continued with the policies of Indira Gandhi National Old Age Pension Scheme, the public distribution system, the income tax provisions, and trying to encourage for microfinance and credit facilities. The other areas of intervention is healthcare, providing them with safety and security, housing facility, productive aging, welfare, multi-generational bonding, as well as the role of media. So these are the primary policy areas of the government under the 2011 policy. The policy has identified an implementation mechanism, under which it has provided that through the Aadhaar facility, senior citizens will be provided with financial assistance and all forms of concessions. The Department of Senior Citizens will be established under the Ministry of Social Justice and Empowerment. There would be constitution of Directorate of Senior Citizens in the various states and the Union Territories. There would be a national as well as state commission for senior citizens. There would be a national council for senior citizens, and the block development officers, Panchayati Raj institutions, tribal councils and Gram Sabhas will be given the responsibility to implement the various programs initiated for senior citizens in the country. So we will briefly mention some of the government schemes which have been initiated for the benefit of the senior citizen. So the Ministry of Social Justice and Empowerment have introduced the integrated program for older persons, under which grants are given for running and maintaining old age homes, daycare centers, mobile Medicare units, multi-facility care centers for older widows. The main objective of the scheme is to improve the quality of life of older persons by providing them with basic facilities like shelter, food, medical care, entertainment opportunities, etc. Implementing agencies are eligible for assistance under the scheme. So specific institutions which can take benefit of the financial arrangements are the Panchayati Raj institutions, local bodies, non-governmental voluntary organizations. So this old age homes which are run by the state can be used by those old peoples who are basically destitute and who do not have anybody to take care of them. So anybody can approach these old age homes and make application to stay in those homes. Another scheme which has been introduced is the Rashtriya Vayoshree Yojana, RVY. It's a central government's scheme which is funded from the Senior Citizens Welfare Fund. Under the RVY scheme, aids and assistive living devices are provided to senior citizens who are living below the poverty level and who are suffering from age-related disabilities like low vision, hearing impairment, loss of teeth, and locomotor disabilities. Different aid and assistive devices can be provided like walking sticks, elbow crutches, walkers, crutches, tripods, quad pods, hearing aids, wheelchairs, artificial dentures and spectacles are provided to eligible beneficiaries. The scheme is being implemented by Artificial Limbs Manufacturing Corporation of India, which is a public sector undertaking under the Ministry of Social Justice and Empowerment. The scheme is being implemented in more than 260 districts and has benefited more than 5,20,000 beneficiaries. These beneficiaries are generally identified by a committee at the district level, which is headed by the district collector, and thereafter kits are distributed through voluntary camps. Senior Citizens Welfare Fund is one important financing mechanism for the various programs running for the welfare of the senior citizens. This fund was notified in the year 2016. All unclaimed amounts which are lying in the small savings accounts PPF and EPF are transferred to this fund. The fund is to be utilized for running schemes for the promotion and welfare of the senior citizens in accordance with the National Policy on Older Persons and the National Policy on Senior Citizens. The schemes for which the funding can be used are promoting financial security of senior citizens, promoting healthcare and nutrition of senior citizens, like providing healthcare programs, mental health services, health insurance schemes, nutrition programs, as well as training and orientation in healthcare of senior citizens, providing for the welfare of the elderly widows, providing for schemes for running old age homes, short stay homes, as well as daycare of the senior citizens. Other schemes which can be introduced under this particular welfare fund are to run education, training, as well as information needs of the senior citizens, as well as to promote research activities in the area of aging. The revised Indira Gandhi National Old Age Pension Scheme is one of the running programs of the government under the National Social Assistance Program. This provides social assistance to the poor households of the aged, widows, disabled, and in case of death where the breadwinner has passed away. This provides in addition benefits by the state governments also. Under this scheme, financial assistance is provided to a person of 60 years and above belonging to a family living below the poverty line as per the criteria prescribed by the Government of India. The central assistance is of ₹200 per month as long as they are in the age group of 60 to 79 years. And for citizens who are above the age of 80 years, the financial assistance is increased to ₹500. And funds are released based on the report submitted by the state government and the union territories. The government has also introduced the Pension Bima Yojana. One of the popular schemes were the Varishtha Pension Bima Yojana, which was first launched in 2003 and has been relaunched in 2014. Under this, social security schemes are being introduced for the senior citizens, wherein they are given an assured minimum pension on a guaranteed minimum return on the subscription amount. These schemes were introduced by the Life Insurance Corporation, which is paid the difference between the actual yield earned by the LIC on the funds invested under the scheme and the assured return of 9% committed by the government. Both the schemes as of now have been closed, but the beneficiaries are still getting the benefit of this particular scheme. One of the recently introduced pension scheme is the Pradhan Mantri Vaya Vandana Yojana, which was launched in May 2017. This is a simplified version of the earlier pension scheme and is also being introduced by the Life Insurance Corporation of India. Under the scheme, on payment of an initial lump sum amount ranging from rupees 1,50,000 for a minimum pension of rupees 1,000 per month to a maximum of rupees 7,50,000 to receive a maximum pension of rupees 5,000 per month. The subscribers are getting an assured pension based on a guaranteed rate of return of 8% per annum, which can be either payable monthly, quarterly, half-yearly or annually dependent upon the need of the pensioner. The duration of the scheme will be for a period of 10 years and the scheme is open for subscription for a period of 1 year, that is from 4th of May 2017 to 3rd May 2018. So till November 30, 2017, a total number of 1,83,842 persons had benefited under this particular pension scheme. The last major initiative of the government is the National Program for the Healthcare of the Elderly, which is being run by the Ministry of Health and Family Affairs, and which basically introduced the scheme during 2010-2011 to address the various health-related concerns of the elderly people. The major objectives under this particular scheme is that at the district level, there should be dedicated health facilities in government hospitals, community health centers, primary health centers and sub-centers, which will be run through the State Health Society. And under this scheme, facilities will be provided either free of cost or at a highly subsidized rate. The facilities which are being provided under this particular program are conducting geriatric OPD and providing 10-bedded geriatric ward at government hospitals at district level, conducting bi-weekly geriatric clinic at community health centers, conducting weekly geriatric cleaning at primary health centers, and providing aids and appliances at sub-centers. Today, more than 520 districts in 35 states and union territories are running this particular scheme. So to wrap up this discussion as regards the status of human rights of the senior citizens, I must be honest enough to say that this discussion, or this academic discussion or this policy-based discussion is at a very, very nascent stage. It has in recent times gained importance keeping in view the incidents of abuse, neglect, which has been largely reported from different parts of the country regarding the well-being of the senior citizens. Indian government has taken some major steps towards promoting and protecting the rights of the senior citizens. The implementation of the Maintenance of Welfare of Parents and Senior Citizens Act is a major initiative which is promoting not only and protecting the rights of the senior citizens in terms of providing them with a financial assistance, but also imposing liability on the children, relatives, as well as the state government as regards protecting the rights of the citizens are concerned. But the concern is the fact that the legislation, in spite of its all laudable objectives, is not being implemented in the manner in which it should be. There is a lot of gap in the implementation is concerned. So proper implementation of these legislations along with the various government welfare programs which the states have initiated to take care of the needs of the senior citizens should be implemented in a much more effective manner at the grassroots level. Only then we can say that the well-being of the senior citizens can actually be assured and all citizens of the country, including our seniors, can live a life of dignity and well-being in India. Thank you so much.